conduct as hearsay. Hearsay is not limited to verbal statement. Conduct could also be a form of hearsay. If we look at these two examples, I think we should be able to understand why, under certain circumstances, conduct would also be a form of hearsay. Suppose we have Sam on trial for criminal assault, for assaulting Bill. And Ted is going to testify, Bill told me Sam assaulted him. Would this testimony be admissible? Of course not. If we understand the definition of hearsay, we know this statement falls within the definition of hearsay. It is an out-of-court statement. It is offered to prove the truth of the matter asserted in the statement. So this statement would not be admissible. But suppose there is no verbal statement. Suppose Ted is going to testify, when I visited Bill at the hospital with a newspaper with Sam's picture on it, I asked Bill, who assaulted you? And Bill pointed at the Sam's picture. And then the issue here is, can Ted testify about this Bill's conduct of pointing at the Sam's picture? The answer is no. This testimony about the Bill's conduct, the conduct of pointing at Sam's picture, is also a form of hearsay. Because if we compare these two examples, we know there is no difference between Bill stated, Sam assaulted me, and Bill pointed at Sam's picture. We know that there is no difference. So in either one of these two cases, Ted cannot testify. But of course, we know in the first example, we have this verbal statement as a form of hearsay. But in the second example, we have this conduct as a form of hearsay. So these two examples would demonstrate, actually demonstrated why conduct under certain circumstances can be a form of hearsay. When we discuss conduct as hearsay, it is important for us to make distinction between assertive and non-assertive conduct. Under the federal rules of evidence, only assertive conduct is hearsay. Non-assertive conduct is not hearsay. So what is assertive conduct? Assertive conduct is conduct intended by the actor to be a form of communication. So in the example we just discussed, when Ted asked Bill, who assaulted you? And Bill pointed at the Sam's picture. That conduct is assertive conduct because Bill intended to use his conduct as a form of communication to identify Sam as the one who assaulted him. So that is a good example of assertive conduct. Non-assertive conduct would be that is a conduct not intended by the actor to be a form of communication. Meaning is non-assertive conduct, that is just people's normal behavior. Under the circumstances, people believe that conduct is a correct conduct to perform. So they just performed that conduct. That is a non-assertive. Once again, non-assertive conduct is a conduct that is not intended to be a form of communication. To give you a simple example, if we're having class and then the class is over, and then I would say the class is over, the class is dismissed, and then what are you going to do? You're going to stand up, you're going to leave the classroom. So your conduct of leaving the classroom is a non-assertive conduct. Why do you leave the classroom? Because the class is over. So that is a correct conduct for you to do. It is not you want to use your conduct of leaving the classroom to convey a message. You do not have such intention. So that is what we mean by non-assertive conduct. Let's look at another example. And suppose you're sitting in the classroom and doing your study, and then suddenly a person comes in. The person takes your computer and runs out of the classroom. Under the circumstances, what you would do? Most likely you would run after the person because you want to get back your computer. But here we have an evidence law issue. And suppose if the person who robbed your computer, the person is now is on trial, if the prosecution would ask a fellow student who actually sees you chase the person to go to court to testify, can the fellow student testify as to your conduct of chasing the person? Would your conduct be assertive conduct or non-assertive conduct? The answer is your conduct is non-assertive. Why do you chase the person? Because you want to get back your computer. It is not you want to use your conduct of chasing the person to send a message to identify the person as a perpetrator. You did not have that intention in mind. At the moment, because your computer is taken, you just want to get back your computer. So that is also your natural and honest conduct under the circumstance. So your fellow student can testify about your conduct because your conduct is non-assertive under the federal rules of evidence. This conduct, testimony about this non-assertive conduct would not be considered a form of hearsay. Now, we need to look at this case, that is the United States versus Zanny. In this case, the defendant had an illegal gambling operation in his house. The police went to his house to conduct the search. While the police were there to conduct the search, they received several phone calls. The callers called in to place bets. And here the evidence law issue was whether the police officer could testify about these phone calls or about this caller's conduct. Of course, we know why the prosecution would want these police officers to testify about these phone calls. The prosecutor wanted to use this evidence to show the defendant indeed was operating this illegal gambling operation in his house. Otherwise, these callers would not really call in to place a bet. But nonetheless, the evidence law issue here was whether the police officers could testify as to this caller's conduct, whether this testimony about this caller's conduct would be considered a form of hearsay evidence. So that was the issue in the case. Before we come to this issue, let's look at some two examples, and then we come back to this issue in Zanny. Suppose Mike actually had this illegal gambling operation in his house. And suppose Mike's neighbor told a police officer, Mike has a gambling operation in his house. Can the police officer testify about this statement? The answer is no, because this is a verbal statement, and this verbal statement is a hearsay. It is an out-of-court statement. It is offered to prove the truth of the matter asserted in the statement. So, of course, we know the officer cannot testify about this statement. But suppose we do not have this verbal statement from the neighbor, and then the police officer asked the neighbor, is Mike having a gambling operation in his house? The neighbor nodded his head. Can the police officer testify about this neighbor's conduct, his conduct of nodding his head? The answer is no, because the conduct of nodding his head is assertive conduct. The neighbor wanted to use his conduct to convey a message that Mike was having an illegal gambling operation in his house. So we know if that conduct was it was assertive conduct, that would be the testimony about that conduct would be hearsay. So the police officer could not testify about this neighbor's conduct. Once again, this conduct is assertive conduct. Now let's come back to what happened in the case in Zanny. In this case, the ruling of the court was the police officer could testify about these phone calls because this caller's conduct calling the house was non-assertive. Why these callers would call the house? Because they wanted to play bets so they could make money. That was the reason why they called in. They did not call in to identify, to convey a message that the defendant had an illegal gambling operation in the house. That was not their intention. So this caller's conduct of calling the house was non-assertive. They did not mean to use their conduct as a form of communication to identify the defendant as a perpetrator. They called simply because they wanted to make money. So that's why they called to play the bets. So that's why this caller's conduct was considered non-assertive. So under the federal rules of evidence, this conduct would not be considered a form of hearsay. In the case, the court actually also discussed this sea captain, an example about this sea captain's conduct in this shipwreck. In this example, there was a shipwreck and all on board were lost, and then the company got sued. So to prove the ship was seaworthy at the time of sailing, the company offered a dock worker to testify that he saw the sea captain, after inspecting the ship, board the ship with his wife. So that is what the company wanted this dock worker to testify. But the evidence law issue is, can this dock worker testify about this captain's conduct? Would this testimony be hearsay? The answer is no, because the captain's conduct in the case should be considered non-assertive. After the captain inspected the ship, and he believed the ship was safe. So that's why he boarded the ship with his wife. The captain did not intend to use his conduct as a form of a communication to say the ship was safe. He boarded the ship based on his honest belief the ship was safe. So his conduct of boarding the ship was non-assertive. So under the federal rules of evidence, once again, the dock worker's testimony about this captain's conduct would not be hearsay because the captain's conduct was non-assertive. So I think it is very important for us to know under the federal rules of evidence, only this assertive conduct is considered hearsay. Non-assertive conduct would not be a form of hearsay.